Hello, ladies and gentlemen. Thank you for standing by. Welcome to the webinar today, brought to you by ComplyRight, Top 10 Compliance Landmines to Watch Out For in 2016. Please note that during the presentation, all participants will be in a listen-only mode. As a reminder, this conference is being recorded Tuesday, January 12th, 2016. My name is Stephanie Thomas, and I am your host today. Thank you, everyone, for attending this webinar, and welcome. I'd like to review a few housekeeping items before we begin. If you would like to ask a question, simply use the chat feature located in the lower left corner of your screen. You can ask questions at any time, and we will answer them as time permits. If you have any audio trouble, please message us in the chat box and we will assist you. Please ensure your speakers are turned on with the volume up. Finally, with all the information we will cover today, please note you will receive an email with a copy of the slides and a recording of the presentation by the end of the week to catch anything you missed. Now I am pleased to introduce you to our speaker today, Eric B. Meyer, workplace lawyer at Dilworth Paxson, LLP. And without further ado, here's Eric. Thank you for being here today.
Stephanie, thank you for having me, and welcome everyone to the webinar. I'm in my pajamas, my traditional webinar material outfit, so I hope you don't mind my attire. Everyone up, please put your hands down. I'll get to you as I can. Well, welcome and Happy New Year, everyone. Well, I can't believe it's January 2016. Time really does fly, doesn't it? It's always exciting to kick off a brand new year and start with a clean slate. Or if not a clean slate, at least a fresh perspective on the year ahead. On the employment law front, I think we can all agree that 2015 was a bit of a wild ride. A whole host of legal changes kept us on our toes and challenged how we run our businesses. Well, guess what? 2016 is shaping up to be just as intense, with numerous changes on the horizon and many government agencies setting aggressive enforcement agendas. This means we all need to be aware and ready, or risk stepping into compliance landmines that could have devastating effects. I don't say this to scare you, that's what lawyers generally do, but I don't say this to scare you, but to alert you to the legal issues that can have a very real impact on your workplace. But that's why we're here, isn't it? Well, that, and I have tomorrow night's Powerball numbers for you. We'll get to those later on. But while I don't have a crystal ball, and actually I don't have the Powerball numbers, I'm sorry, I do have a keen understanding of the legal issues already heating up for 2016. In the next hour, I'll go over the 10 employment law matters every employer should be watching closely this year. Just as important, I'll give you direction on the best strategies in HR practices for reducing risk and remaining compliant through it all. That's even better than a $1.5 billion Powerball jackpot, am I right? Among the areas we'll cover are how to meet the latest Affordable Care Act tax reporting requirements, which of your workers may be affected by pending Fair Labor Standards Act overtime rules, why the government is cracking down on independent contractor versus employee classification, or should I say misclassification, the latest OSHA HazCom standards and record-keeping rules, and ways to keep politics out of the workplace in an election year. We have a lot to cover, so let's get started. The first compliance landmine I'm going to talk about are the new Affordable Care Act reporting requirements. But before I go over that with you, I'd like to take a quick poll. I'm interested in how many full-time or full-time equivalent employees you have, a specification that will be clear to you in just a moment.
Okay, so if everyone can participate in the poll now, just to see where your company stands. Okay, I'm closing the poll, and it looks like the majority of you have 50 or more full-time employees.
Well, thank you, Stephanie. And for the audience, although most of you answered 50 or more, a portion of you answered fewer than 50 as well. The Affordable Care Act reporting requirements apply in both cases, although more so if you're a self-insured employer, more on this later, Also, a handful of you responded that you're not sure. Well, less than a handful are not sure, which tells me you may need some guidance on determining your status with the requirements. I'm sure some of you clicked the other options because you didn't want to be in the 0.7% that weren't sure. So we'll go over that for you anyway. Here we go. All right, there we go. The Affordable Care Act, or ACA, represents the most comprehensive changes to the nation's healthcare system in decades. The Affordable Care Act's primary goal is to expand health insurance coverage by guaranteeing access to private health insurance and expanding the Medicaid program. The law also put into place the Employer Shared Responsibility provision, which places new requirements on employers who have historically been the biggest suppliers of private health insurance in this country. Beginning this year, regulations under the Affordable Care Act require certain employers to file information returns with the Internal Revenue Service, as well as provide summary statements to employees. The Affordable Care Act forms, known as 1095 forms, capture certain health insurance coverage details for full-time employees and their dependents. This includes verification that employees are receiving affordable minimum essential coverage as determined by ACA standards. Although time is of the essence with this first landmine, you should know that the IRS just recently announced an extension of the reporting deadlines. Woohoo! Previously, you would have needed to file your 2015 forms on the same schedule as W-2s and 1099s. Under IRS Notice 2016-4, however, the new deadlines for 2015 Affordable Care Act forms filed in the 2016 calendar year are as follows. March 31st to furnish employees and recipients with Forms 1095B or 1095C, and that's rather than January 31. May 31st to file forms with the IRS is the deadline for using paper rather than the old deadline of February 29, and June 30 is the deadline to submit the form to the IRS if filing electronically rather than the old deadline of March 31st. Generally speaking, whether or not your business is responsible for reporting the health insurance coverage of your employees depends on the size of your business and whether you're insured or self-insured. The biggest impact of these regulations is on employers who had 50 or more full-time or full-time equivalent employees in the preceding calendar year. So let's review those distinctions now. A full-time employee averages at least 30 hours of service per week during the calendar month, or 130 hours in a month. These hours of service represent each hour an employee is paid or entitled to payment, including vacation, paid holidays, sick days, jury duty, military duty, and other leaves of absence. Employees working part-time also count towards the number of full-time workers you have, a calculation that makes them full-time equivalent employees, or FTEs. I won't get into the specific calculation here, but it's covered in the Comply Right webinar on ACA reporting. I'll point out in a minute. Once you've run the math, know that if your full-time and full-time equivalent employees add up to 50 or more, you're required to file the 1095 forms. And I know that was just a mouthful right there, and I wanted to remind all of our listeners that everything I talk about today will be distributed to you in a follow-up email. You'll get the slides, recording, and some pertinent links. To satisfy the reporting requirements, you must complete Form 1095C and the 1094C transmittal form. If you're a fully insured employer, you'll complete Parts 1 and 2. With those of you with self-insured plans, will complete Parts 1, 2, and 3. Every employee who is eligible for insurance should receive a 1095C. That includes eligible employees who decline to participate in your health plan. Another point about the ACA reporting requirements, there is considerably less responsibility for smaller businesses, which the ACA defines as those with fewer than 50 full-time employees. If this applies to you and you're a self-insured business, you'll need to fill out the 1095B and 1094B transmittal form to report the name, address, and Social Security number or date of birth of covered individuals. A bit of reference about insured versus self-insured, since it can trip up people. A self-insured or self-funded employer contracts with an insurance company to administer its plan, but the company pays medical claims out of its own funds. With a fully insured health plan, on the other hand, you pay the insurance carrier premiums, and the provider, such as Humana or Blue Cross Blue Shield or Aetna, pays health care claims based on the coverage benefits outlined in the policy. And here comes the risk element with this first compliance landmine. If you're an ALE and don't offer health insurance to your full-time employees, that means the law's requirement for minimum coverage and affordability. You may be subject to financial penalties. You'll also need to mind the filing deadlines to avoid IRS penalties, which start at $250 per filing and can reach into the millions for larger businesses. Needless to say, this is a very complex topic that I can only touch on briefly in this presentation. But for more information and guidance on completing the necessary IRS forms, you can check out an earlier webinar, Mandatory ACA Reporting in Effect for 2016, How to Meet the New Requirements. Links to this and other great resources by ComplyRight will be listed in a final slide as well as in a follow-up email. One more thing. Relying on a reputable IRS-authorized e-filer provider like eFileForBiz.com can help you meet the demands of the new ACA reporting requirements. Again, more information on this secure and efficient service will be available after today's presentation. And now we'll move on to the next compliance landmine. Proposed changes to the overtime rules. This is very near and dear to my heart. All employers should be monitoring the proposed overtime regulations, which are expected to be finalized sometime in 2016. The early word we got was towards the end of the year. The more recent word we've gotten is most likely July, summer months. So be on the lookout for that. Here's what's happening. Under current FLSA regulations, non-exempt employees are entitled to overtime pay at a rate of 1.5 times for any hours worked in over 40 in a work week. Let me say that again. You're entitled to overtime pay as a non-exempt employee for hours worked over 40, and that overtime pay is paid out at a rate of 1.5 times the regular rate of pay. Most hourly employees are non-exempt. Salaried employees, however, are generally non-exempt, but they're only non-exempt from overtime if they earn at least $455 per week. That's $23,660 per year. And they also have to meet one of the executive, administrative, or professional white-collar exemptions. There are a few other ones as well, which I'm not going to focus on today. But the main exemptions are executive, administrative, and professional. Each of these exempt categories assumes a specific set of job duties, such as advanced knowledge in a certain field, exercising independent judgment and discretion, and or supervising at least 2 employees. Under the proposed new law, the minimum salary level threshold would more than double to $50,440 per year. So right now it's $455 per week or $23,660 per year. It's going to more than double to $50,440 per year. Plus, there could be changes to the duties tasks, which may be dropped altogether or made less restrictive in favor of employee eligibility. The DOL is also proposing raising the salary threshold for highly compensated employees from $100,000 to more than $120,000 per year, making applicable employees non-exempt and entitled to overtime. The proposed overtime regulations are designed to extend overtime protections to millions of lower-paid white-collar employees, regardless of the nature of their job. This is essentially a substitute for raising the minimum wage. The last adjustment to the minimum salary level was 10 years ago during the Bush administration. As part of the proposals, the minimum salary will automatically increase each year based on the 40th percentile of weekly earnings for full-time salaried employees, as determined by the Bureau of Labor Statistics. Because of the potential, I'm talking before I'm on the next slide. Because of the potential scope for these proposed changes, preparation is key. To accommodate these changes, you may decide to, 1, you could increase salaries for employees earning less than $50,440 annually, so they'll still be exempt from overtime. That's assuming they meet the job duties test for executive, administrative, professional, or another applicable exemption. Another option is that you could reclassify affected employees as non-exempt and pay them on an hourly basis and try to restrict their overtime thereafter. This is all easier said than done, I know. You'll have to crunch the numbers and consider the impact on your payroll budget. Plus, there's the issue of morale and employee engagement if formerly salaried employees who have scheduling flexibility to come in late or leave early for personal reasons are made hourly and must now account for every hour worked, or are restricted from going over 40 hours to keep overtime costs down. Needless to say, we'll all be keeping a close eye on this particular legal matter. I know it's one of the top ones that I'm looking at personally for my readers of my blog and my clients, very importantly, since it could affect so many workers and employers. For continued updates, visit the Labor Law Compliance blog at postertracker.com or the ComplyRight website at complyright.com. Also, as a reminder, you'll get all of this in a follow-up email, this recording, the slides, and links for more information. So moving on from the salary level test, let's talk a little bit about a related topic, and that's misclassification of independent contractors. Relying on independent contractors, including freelancers, consultants, and project workers to meet the needs of your business is perfectly acceptable. What's not acceptable, however, is wrongly classifying employees as independent contractors to cut costs. And it's happening more and more in companies across the nation. Whether you've done it intentionally or it's an honest oversight, misclassification carries a heavy financial risk. In fact, the costs you save initially from Social Security and Medicare taxes to unemployment insurance premiums could add up to a hefty amount of back taxes and penalties down the road. More vigorous enforcement by the Department of Labor means every employer needs to be on high alert with the classification rules. Since 2008, the Department of Labor has hired thousands of additional investigators to detect and deter companies from misclassifying employees as independent contractors. At the same time, many state agencies are entering into a special agreement with the Department of Labor to share information and coordinate their enforcement efforts. Under these arrangements, if a state agency finds out an employer is misclassifying workers to skirt unemployment taxes, for example, the Department of Labor will be contacted. As a next step, the Department of Labor can then investigate the employer to determine if it's also evaded federal taxes. These combined efforts are clearly making an impact. In 2013, Department of Labor investigations led to more than $83 million in back wages for about 108,000 misclassified workers in low-wage industries such as janitorial, food, construction, daycare, and hospitality. If you've wrongly classified a worker, the risk of getting caught is always present. And as mentioned, penalties are steep, including back taxes. So we're talking about Social Security, Medicare, unemployment for up to 6 years plus penalties. Back wages, including overtime pay for up to 3 years. There's liquidated damages and penalties and possible employee lawsuits. And what we focus on here is just a Department of Labor investigation. If one of your employees whom you've misclassified decides to retain counsel, that could certainly lead to a single employee action or a collective action or a possible class action. There's also back premiums for workers' comp insurance for as many years as the worker relationship has existed, plus possible employee lawsuits. Obviously, it's never been more important to get worker classification right. For guidance on the classification rules, please check out the link we've provided at the end of this webinar to a ComplyRight presentation from the recent Small Business Expo in Atlanta. Among other things, you'll learn how to determine if a worker is an independent contractor or an employee based on 3 key areas: behavioral control, financial control, and type of relationship. It generally does come down to control. As a basic rule, the more control you have over the worker and the worker's contributions to the business, the more likely the individual is an employee and not an independent contractor. To protect yourself from misclassification issues, you should choose contractors with skills and expertise to work independently without training and supervision, that have a business name, an employer identification number, and that have other customers. Also, treat contractors as vendors under accounts payable and write checks to the business name. Another thing I want to point out too is just because you have a contract with an individual and that contract says that it's an independent contractor relationship doesn't make that contract dispositive. If you're exercising the requisite amount of control, there's other indicia of an employer-employee relationship. That contract, that independent contractor agreement is not going to be able to carry you through the day if you're sued for misclassification of employees. Now let's move on to another issue that's near and dear to me, and that's ban the box. For where I am giving this webinar from in Philadelphia, there was legislation recently enacted by our outgoing Mayor Nutter, who essentially beefed up the existing ban the box rules. So let's talk a little bit about it more generally. What is ban the box? We've heard it before, but what is it? To date, 18 states and more than 100 cities and counties have passed laws designed to reduce hiring barriers for individuals with criminal histories. These are known as ban the box laws because they seek to eliminate the question, have you ever been convicted of a crime, on job applications. These laws restrict you from inquiring about an applicant's criminal record until the job interview, or in some cases, after the applicant is qualified and offered a position. That's what just is about to go into effect in Philadelphia. You can't ask about a criminal conviction until you've made a conditional offer of employment here in Philadelphia. The first state to pass ban the box was Hawaii, which eliminated the question for both public and private sector employers in 1998. On a local level, the city of brotherly love, Philadelphia was the first major city to ban the box for public and private employers in 2011. While the intent of the legislation is the same, the specifics vary. For example, when they were introduced, ban the box laws applied only to government contractors and subcontractors. In recent months, however, the laws have expanded to target private employers as well. Be aware that 11 of these states regulate how public employers may use criminal records: California, Colorado, Connecticut, Delaware, Georgia, Maryland, Nebraska, New Mexico, Ohio, Virginia, and Vermont. The other 7 states, Hawaii, Illinois, Massachusetts, Minnesota, New Jersey, Oregon, and Rhode Island, extend their ban the box laws to private employers as well. As you might imagine, there's some gray area regarding the workplace rules with ban the box legislation. It's important to understand that you're not prohibited from conducting a legally sound background check on an otherwise qualified individual, nor are you required to hire every individual with a criminal record. Instead, the purpose of ban the box legislation is to shift the criminal history inquiry from the initial application stage until later in the hiring process when you hold an interview or extend a conditional job offer. How can you be confident you're in compliance with the new ban the box laws? First and foremost, review and revise all employment applications to be certain they don't include a criminal history question. Obviously, especially true if you're in a ban the box jurisdiction. Or if you're a national employer that operates in many different states, you may want to consider having a uniform application that just gets rid of the box, so to speak. Next, modify your hiring procedures to delay any inquiries about criminal history until it's appropriate, making sure your hiring managers understand the requirements and how to handle conversations about criminal history with potential hires. To learn more, check out the webinar I had the pleasure of presenting for Comply Right last year, The State of Hiring, How to Comply with Ban the Box, and Other Hiring Laws. It covers the impact of the Ban the Box movement on your hiring process, including the importance of state-compliant job applications, and how and when to conduct proper criminal background checks. I'd also commend you to check out what the EEOC is doing with respect to background checks, both criminal and credit histories. They're taking a pretty aggressive position on the use of criminal background checks and how they can be used and the disparate impact that these checks, both criminal and credit, can have on minorities. So keep that in mind as well. Not part of ban the box legislation or the ban the box movement, but certainly working in tandem. To learn more, check out, I said we did that already. We're about a third of the way through the webinar, so I'd like to pause to conduct another poll. This time I'm interested in the industry your business is in as it pertains to OSHA and your safety practices.
So Eric, the options in the poll today are that your business is in one of the industries, general industry, and that could include manufacturing, the service sector, and healthcare, the construction industry, the maritime industry, or agriculture. And it looks like the majority of people today are in the general industry category.
Okay. So since most of you have answered, and I'm going to close the poll now, it looks like the majority of you, as Stephanie said, are in the general industry. So this is a broad category. It covers a lot of businesses, especially lower risk businesses. And I'm not surprised. Now that I know where most of you stand industry-wide, I'm going to move into the next potential pitfall of 2016. Just because you're a low-risk business doesn't mean you can ease up on OSHA compliance. OSHA compliance is a big and complicated topic. Not to worry, though. This portion of the webinar isn't about the hundreds of standards that OSHA enforces. Of course, upholding these standards is critically important, but right now, I'd like to remind you of the latest OSHA requirements that may affect you in 2016. Let's start with the revised OSHA HazCom standards. As I'm sure you're aware, OSHA aligned the HazCom standards with the United Nations Globally Harmonized System, or GHS, to establish more uniformity and better protect workers. As part of the new standard, all employers with hazardous chemicals were expected to train workers on the modified labeling system and how to interpret a safety data sheet by December 1st, 2013. Full compliance with the final rule is effective June 1 of this year. By this date, you're responsible for updating your written workplace HazCom program to incorporate the new GHS requirements and for completing training for employees. Be aware, too, that by this date, the transition period ends for following the existing labeling system, the new GHS, or both. OSHA estimates that more than 5 million workplaces are affected by the new standard. And while the connection to certain industries may seem obvious, such as construction, manufacturing, and healthcare, even businesses that carry certain types of cleaning products must comply. Before we move on, I want to share a few other critical OSHA developments. OSHA issued new regulations effective January 1 of last year that, first, expand the list of severe injuries you must report to OSHA. Second, they require you to report work-related fatalities within 8 hours. Third, they require you to report work-related inpatient hospitalizations, amputations, or loss of an eye within 24 hours. And finally, they changed the list of industries exempt from keeping records. Also, OSHA released a new version of the It's the Law Job Safety and Health poster in May of last year. Although it's a non-mandatory change, let it serve as a reminder that all employers must have the federal OSHA poster on display. Finally, and here's where the risk of noncompliance gets very real, OSHA will increase fines for safety violations in 2016 for the first time in a quarter century. Under the Federal Civil Penalties Inflation Adjustment Act, that's the Federal Civil Penalties Inflation Adjustment Act of 2015, OSHA will impose a one-time catch-up assessment that could amount to a nearly 80% increase in OSHA fines this year. Specifically, OSHA fines for willful or repeat violations could increase from a current max of $70,000 per violation to $125,000. Fines for serious and other than serious violations could increase from $7,000 per violation to approximately $13,000 per violation. The catch-up adjustment will take effect no later than August 1st of this year. As Assistant Secretary of Labor for OSHA shared, simply put, OSHA penalties must be increased to provide a real disincentive for employers accepting injuries and worker deaths as a cost of doing business. The stakes are higher than ever for maintaining a safe workplace. For insight on how to improve your safety program, prevent workplace accidents, and meet reporting and record-keeping requirements, check out the Comply Right webinar, How to Create a Safer OSHA-Compliant Workplace. And of course, you can catch up on everything I discussed over the last couple minutes when we send out a follow-up email with a copy of the slides, the recording, and helpful links. For now, let's move on to EEOC protections for LGBT employees. As a conscious employer, you know that a fair and compliant workplace embraces diversity and guards against discrimination of any kind. Equally important, these workplace protections keep pace with our changing times and sensitivities. Recent activities by the EEOC, as well as legal developments on the city, state, and federal level, reflect these sensitivities, specifically regarding rights for lesbian, gay, bisexual, and transgender, or LGBT employees. Take the matter of sex discrimination in the workplace. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, national origin, religion, and sex. In July 2015, the Equal Employment Opportunity Commission issued a ruling to expand that definition. The agency clarified that discrimination against an employee for sex-based preferences, such as sexual orientation, is considered sex discrimination. It stated, quote, discrimination on the basis of sexual orientation is premised on sex-based preferences, assumptions, expectations, stereotypes, or norms. Years prior to this ruling, the EEOC determined in Macy versus Holder that intentional discrimination against transgender individuals was a form of sex discrimination and actionable under Title VII. Since that case in 2012, the EEOC has handled numerous claims of sexual orientation discrimination from private and public sector employees. And as I was just telling Stephanie before we went live on this webinar, the EEOC just filed an amicus brief or a Friends of the Court brief in the 11th Circuit in a case where the main issue is whether Title VII of the Civil Rights Act of 1964 covers sexual orientation because it bans discrimination based on sex. So I'll be keeping a very close eye on the outcome of that 11th Circuit case. The expanded definition of sex discrimination under Title VII isn't the only development on the legal front. In other moves that affect the LGBT community, the United States Supreme Court decided on June 26, 2015 in Obergefell versus Hodges that all states must recognize and issue licenses for same-sex marriages. The decision was one of the most significant changes to constitutional law in years, with far-reaching implications for employers. In light of these legal developments, you should be especially diligent about preventing discrimination or harassment due to a person's sexual orientation or gender identity. Additionally, from an HR perspective, you need to ensure you're extending spousal privileges for same-sex married couples, including Family and Medical Leave Act rights. Same-sex spouses are now eligible for FMLA leave for qualifying conditions or military deployment. Benefits plans for same-sex spouses are also eligible for any benefits that include spousal participation, such as group medical policies or other benefit programs. And company policies. Keep a close eye on other company policies with spouse-specific terms, such as bereavement leave, non-FMLA medical leave, and other time off to ensure same-sex married couples are covered. I can tell you that many Fortune 500 companies have taken it upon themselves, have long done this before Obergefell, to ensure that to take steps, affirmative steps, to ensure that sexual orientation discrimination is eradicated from the workplace, and that all employees are treated as equally as possible without regard to their sexual orientation, or LGBT status generally, I should say. For continued updates that can help you remain on the right side of the law with your LGBT employees, visit the Labor Law Compliance blog at postertracker.com or the ComplyRight website at complyright.com. For the 7th compliance landmine, you need to be on the lookout for possible changes to the Form I-9, which must be completed for all newly hired employees to verify their identity and authorization to work in the United States. In July of 2013, the U.S. Citizenship and Immigration Services, or USCIS, announced it was developing a new version of the form with enhancements to help employers comply with the law and reduce common mistakes when completing the form. Then, in November of last year, the USCIS published a notice in the Federal Register informing the public of proposed changes to Form I-9 with an invitation to provide comments for the next 60 days. The comment period is going to close on January 25th, this month, January 25th, 2016. You can learn more about the proposed changes to the I-9 portion of the USCIS website. You see a link up on the screen. That link will be obviously in the follow-up email that you're sent following this webinar. Because the current form expires on March 31st of this year, it's logical to assume an updated form is forthcoming. In the meantime, continue to use the current version of Form I-9 until the Office of Management and Budget approves the proposed version and the USCIS posts it on I-9 Central. Another point here, more than 500,000 companies now use E-Verify, a free internet-based system operated by the U.S. Department of Homeland Security to confirm a new employee's work authorization status. E-Verify works in tandem with your I-9 documentation process, running a cross-check of employees' I-9 information against records in the DHS and Social Security Administration databases. Most employers are pleasantly surprised at how fast the system works. On average, you receive an initial response of work authorization within 3 to 5 seconds. If this sounds good to you, 2016 may be the year for your business to start using E-Verify. So how are we doing? I'm going to take a sip of my tea here. I'm dealing with a cold, and so far I'm doing all right. I'm not hacking up a lung. I know we've covered a lot so far, and I appreciate your taking the time out of your day to attend today's webinar. Now we're going to pick up the tempo a bit and cover the last 3 compliance landmines. And before that, let's get to a final poll, because I'm going to touch on mandatory labor law posting compliance. I'd like to see if you're aware of a particular aspect of these requirements. All right, Stephanie, I think we're ready to close this one out.
Yep, I just closed it, and then the majority of you said true.
All right. I'm going to move to the next compliance challenge we're facing this year, and you'll learn the answer to this poll question in just a moment as we discuss the rise in city and county regulations and postings. Labor law posting compliance can be challenging enough on a federal and state level, with up to 21 required postings in a given state. But if you have locations in certain cities or counties, you'll now have additional postings to monitor, up to 7 additional postings in some locations. Then there's the other specialty postings that might apply, for example, if you have government contracts, or if you're in certain highly regulated industries like healthcare or food service. Can't imagine how many posters you must need in some cities in California. Thankfully, I don't practice law there. Plus, here's the answer to the poll question. Cities and counties have the discretion to pass laws more generous to employees than state and federal laws. The city and county postings cover a variety of employment laws similar to state posters, such as minimum wage, paid sick leave, that's one we have here in Philadelphia, and discrimination. That's another one we have here in Philadelphia, for example. We've specifically banned discrimination based on sexual orientation. And remember, you have to post these city posters in addition to the state and federal posters. For example, if your city has a minimum wage poster and the minimum wage is higher than the federal or state, you will have to post the state and federal even if they seem to conflict. Oh, whoops, I got ahead of myself. I apologize. We don't have time in this webinar to cover every city and county posting requirement, but the main takeaway here is that you need to keep an eye on them and update your postings accordingly. You can learn more about this aspect of posting compliance and how to manage it with a convenient posting service like Poster Guard Compliance Protection. By watching the Poster Guard webinar, city and county required postings, it's more than just a trend, it's the law. Again, you'll find the link to this and other helpful resources at the end of this presentation and in the follow-up email that we'll be sending out after this webinar is over. All right, 2 more landmines left. Cloud-based services. In today's increasingly fast-paced and digitally driven world, manual processes are being nudged out by newer, faster electronic options. Take cloud computing. A novel concept less than 10 years ago, cloud computing is rapidly changing the way companies do business. Now, rather than store data on hard drives or on-site servers, you can simply access information via the internet. The cloud platform makes data accessible anytime, anywhere, and from any device, such as laptops, tablets, and smartphones. The result is reduced costs overall, easier file sharing between employees, more flexibility due to around-the-clock access, and greater integration with providers for your day-to-day operations like HR, marketing, and accounting. While this is good news, any shift in how you do business, especially when it involves critical files and data, requires a careful approach. To avoid risk and get the most from cloud-based applications, you need to weigh a handful of important factors. First, security. To protect your data from unauthorized use and other risks, a cloud computing service should offer password protection, the latest data encryption, and SSL enforcement for secure HTTPS access. Second, user-friendly platform. Seek out services that are logical and intuitive, where you can navigate the site quickly and easily. 3, reasonable cost. Make sure you understand what is covered by the monthly service and what is extra. Verify the system requirements too, as this could create additional costs for your business if you don't have the recommended high-speed internet connection or operating system. 4th, company reputation. Do your homework here, from finding out how long the company has been in business and asking for customer references to reviewing the privacy policy or other written assurances regarding authorized access and full data protection. And 5th, support. Professional support should be readily available if you encounter any problems. Ideally, you'll have a few different ways to reach someone, whether email, instant chat, or a telephone call if you need help. I'm going to add 2 more bullets that aren't up on this slide. First is making sure that you have cyber insurance coverage for a potential data breach. Yes, your employees can be either intentionally or unintentionally responsible for a data breach, so it would be good to have insurance in the event that a data breach does happen in your workplace. And another bullet, I'm hearkening back to something I got to earlier with the Fair Labor Standards Act, is if you're going to have non-exempt employees using their smartphones and accessing data, quote-unquote, off working hours, that is compensable time. When non-exempt employees are doing work, you're supposed to compensate them for that time. So keep that in mind and factor in whether you want your non-exempt employees accessing this information, quote-unquote, off the clock. If you're contemplating moving to the cloud to boost your company's efficiency and productivity, read the article, 5 Important Considerations Before Doing Business in the Cloud at complyright.com for additional insight. And now, folks, we are in the home stretch of our webinar. Last but not least, the 10th compliance landmine is politics in the workplace. In what's shaping up to be one of the more controversial, interesting presidential elections, political talk is everywhere these days. From our daily news feeds, it's all across my Facebook, I just try to ignore it, to conversations with family, friends, and coworkers. And as we're all too aware, people can become quite vocal, even downright ugly, about the candidates and their campaigns. How do you keep it in check in the workplace? Taking a strict stance against all political discussions and activities is probably not in your company's best interest. I don't know how you're possibly going to enforce that, but neither is allowing a political free-for-all. While entitled to their beliefs, employees shouldn't be allowed to disrupt the workplace with their political rants or start heated debates on sensitive issues. So what should you do? Start with a political activities policy that provides direction for employees and helps prevent misunderstandings. Be clear with your policy, not only on politics, but on any other form of individual expression based on personal opinions or beliefs. So, for example, having a non-proselytizing policy as it relates to religion is something you'd want to consider for your workplace too. This political discussion policy can in part be modeled off of that. Outline the rules and be prepared to address anyone who breaks those rules fairly and uniformly. If you decide later that your policy is lacking, you can always make changes as long as they don't unfairly target a specific employee's act of political expression. Beyond a written policy, the next best way to prevent problems is to educate your employees on proper behavior. Putting reasonable parameters around political expression and activities can help prevent workplace conflicts, hurt feelings, and even employee lawsuits. In addition, be sure all managers and supervisors uphold your company's policy. They should enforce restrictions consistently and avoid showing bias or preferential treatment toward any particular political party or candidate. Inconsistency is not only bad for employee morale, but it may also lead to legal complications. And folks, let me underscore here that what we were just talking about pertains specifically to businesses in the private sector. I'm not even going to get into public sector employers. This is for businesses in the private sector. Finally, there's a matter of time off for voting. You should encourage employees to participate in the election process, which includes allowing them to take time off from work to vote if their work schedules don't provide enough time before or after their shift. Keep in mind that state laws vary on the reasons employees may take time off from work to vote. Local laws do too. The amount of time they can take and whether you must pay them for this time. If you'd like more guidance on how to handle political expression in the workplace, stay tuned for more information from ComplyRight. We'll be covering this topic in more depth in a webinar later this year. I'm taking my breath there, taking a little sip of tea. I made it through. My voice held up. Didn't lose too many participants on this webinar, so it sounds like you guys were happy with it. This wraps it up. I hope today's presentation gave you a clear view of the emerging employment risks and how to prepare for and manage some of the bigger compliance challenges. As you've learned, a lot of these legal and regulatory matters are already in motion and will take greater shape in the coming months. With an attitude toward reducing risk and protecting your business, you should verify if Affordable Care Act reporting requirements apply to you and take steps to gather data and complete the proper 1095 forms, including sending recipient copies and e-filing with the IRS on schedule. Determine which of your workers may be affected by pending FLSA overtime rules and how you'll cover the payroll costs if more of them become eligible for time and a half. That's something that you really need to be proactive about. I wouldn't wait until the rule changes before you start at least addressing this as an issue, because the regulations are going to change at some point, most likely this year. Make absolutely certain that you're properly classifying all your workers and not counting anyone as an independent contractor that should be an employee instead. Also, you want to review the latest OSHA HazCom standards and record-keeping rules that may affect your training efforts and response to workplace injuries. Also, remain open to moving more of your operations to cloud-based services, but only after you've done your homework and picked the most reputable providers. And last but not least, gear up for an interesting year due to the presidential election and the ongoing political chatter. We'll put some parameters about what employees can and can't do while on the job into effect now. So here are some additional resources that are hyperlinked. I'll leave those up here for a second or two. Hopefully if you click on them, it's not going to take you away from this presentation. Of course, these resources will also be in the PowerPoint deck that we send out, that ComplyReady, sends out after this webinar concludes. And Stephanie, what do you say in the final couple of minutes? I take some questions.
Yes, that sounds good, Eric. Thank you so much for leading us throughout the presentation. I do want to add that additional resources slide, you couldn't really click on them, but I did add a link in the chat that'll take you to that slide, so you can click from there. You could save that PDF to your desktop to access those resources at a later time, or like we've said, you can get that link in the follow-up email you'll get this week. So, and I'll also send an email address in the chat. If you, for some reason, did not get the email in your inbox, if it went into spam, you will just email me and I'll get that link of resources to you so you can follow up to get more information. But now it's time for questions. We've got about 5 minutes to answer questions. Thanks, Eric.
All right, Stephanie, I'm going to scroll up. I see one question seems to pop up more often than the other one. It's, are you as handsome as you sound? Yes. Yes, I am as handsome as I sound. Let's see. We don't have many questions left after that. Let's see. Here's one. How will the NLRB's initiative to prohibit employers from limiting employees' ability to speak freely affect a policy prohibiting politics in the workplace? Great question. So employees have the right, whether you're in a unionized workplace or not, if you're covered under the National Labor Relations Act, which is most private sector employers, employees have a right to discuss amongst themselves terms and conditions of employment, wages, benefits, my employer's a jerk, that kind of thing. That's called protected concerted activity. Discussing politics in the workplace is separate, at least on its face, from terms and conditions of employment. So that shouldn't be invoked under the National Labor Relations Act and the board's initiative. That said, I could imagine a conversation in which a manager is compared to a certain political candidate, and certainly that would be covered under the National Labor Relations Act. So if you were to discipline the employee from comparing them to a particular political candidate, then you might find yourself with an unfair labor practice charge. Here's another question. I'm a public employer in Colorado. Am I able to ask, have you ever been convicted of a law violation? Have you ever been convicted of a crime? I don't think so, but I'm just following up. Well, I'm not licensed to practice law in Colorado, so I can't give you specific legal advice on that issue. I would suggest that, hopefully, I'm trying to remember back to the webinar, Stephanie, that we did before. I don't know if it gets that granular, but there may be some links in the prior webinar to some state resources. Also,
yes, we do link to a resource or two in that presentation if you want to check that out in the link I sent in the chat.
Yeah, and while Google is no substitute for obtaining counsel from a good local lawyer, you may be able to find the answer there, but if in doubt, call up your local employment lawyer and find out the answer to that question. To be safe, you just may want to ban the box. Let's see, what other questions do we have? Question, where does landscape contractor fit? I assume that question is, are they an independent contractor or are they an employee? Well, I'll give you my lawyerly answer. Of course, it depends. It depends on the relationship that you have with a landscape contractor, how much do you control the landscape contractor. For example, is the landscape contractor wearing a uniform that you provide, Are you providing the landscaping equipment, the tools? Are you telling them when they have to show up? Are you giving them a W-2 or a 1099? I mean, are they procuring their own insurance? These are the indicia of an employer-employee relationship. If conversely, the landscape contractor is told that once a week we need to have our grass clipped, and we don't care when you do it, you just show up and get it done, and they are performing landscape services for a bunch of other companies, then that sounds more like an independent contractor relationship. Let's see. What other questions do we have? Oh, I'm scanning through. I apologize, folks. Is a highly compensated employee any employee who is paid over $100,000? There's more to it than that. You have to at least fulfill some of the responsibilities or some of the criteria that are set forth in the either the executive or the administrative or learned professional exemptions. So it's not just $100,000 alone. Also, if you pay someone on an hourly basis more than $100,000, I believe that the highly compensated employee exemption doesn't apply. You still need to be salaried. How are we doing on time, Stephanie?
Eric, we are at 3 o'clock, so now we will close questions. I did put something in the chat to email us. If your question was not answered, we'll get an answer to you if you just send us an email. But thank you, Eric, for being with us today. We've covered a lot of questions. We've covered a lot of landmines. So hopefully as an employer, you're all set to successfully tackle 2016 and not have any landmines come your way.
Well, Stephanie, thanks for having me, and I'll let you get to the plugs.
Great. Before we sign off today, I would like to invite you to next month's webinar by Comply Right. That's going to be next month, February 9th at 2 p.m. Eastern. 5 easy steps to prevent accidental discrimination when hiring. A brief description of this webinar. Most hiring managers know not to rule out an older worker just for being older or ask a female applicant her plans for having a family. But are you aware of the many other potential discrimination pitfalls when hiring new employees? Are you confident your hiring process treats every job seeker equally and fairly according to the various federal and state discrimination laws? This webinar will teach you 5 simple steps you can take to keep yourself from discriminating by accident. Learn what you can say, do, and ask at each stage of the hiring process to protect your own interests while staying within the law. This was an informative session today, and I thank all of you for staying on with us during the hour. Thank you, Eric, for presenting, and everyone have a great day.